As a result of the collapse of the Champlain Condo Tower, this incident will set off years of litigation as victims and their families look to find fault among the building's management, engineers, and architects. Joining us now to discuss, Kevin Hirzel, a condominium attorney. Kevin, your practice focuses on legal issues relating to condo board regulations as well as construction flaw litigation. So in terms of responsibility in this case, can the original designers or even architects be sued for that flat slab of concrete that didn't let the water drain that many are saying led to this collapse?
So I think you're going to find that there's going to be a difference here between responsibility and legal liability. So the statute of limitations is really going to allow them only to go back 10 years against the original developer here. There is a legal theory that I think is going to be pursued in this case. It's called fraudulent concealment. And what that does is if you can show that somebody committed fraud and made it impossible for you to discover a claim, it extends the time period in which you can sue somebody, so you get additional time to sue.
Well, you mentioned a 10-year sort of time frame we're working with. And we learned last week, it was revealed to the media that there was a 2018 report, so that would fall into that time frame, done by engineers. It showed some structural issues with the building, also revealing that many of the condo board's members wanted out of the building and their role on the board after that report was made known here. Is that some sort of legal path that these families could seek out? Again, the engineers who did that initial report and then also the lack of action from this condo board?
Well, certainly there are going to be claims, and there have been claims against the engineer. If their conduct fell below the standard of care, which could be the case here, they did not warn that it's possible that there was a building collapse in any of the reports. I didn't see any sort of time frames as to when work had to occur here. So certainly they are going to have liability. And there's going to be an issue, with pursuing the board, though. Similar to, some of the governmental issues or the governmental entities, they have liability protections under state law. So negligence is not going to be enough to hold the board responsible. You're going to essentially have to show that they acted intentionally here. Similarly, there was a lot of turnover on the board. These were the same people that lived here, but they needed the assistance of the condominium owners in order to increase assessments to actually do these repairs. From what I can tell, there was a lot of infighting that was going on here that made it difficult for the condominium board members to do their job, which resulted in that turnover. So certainly, unless they acted grossly negligent or intentionally, which does not appear to be the case here, it's going to be hard to hold them individually responsible.
Briefly, Kevin, if you were advising some of the victims or their family members as well, what path would you recommend to be the most successful in court to get some sort of justice to this tragedy?
Well, the big issue here is going to be collectability. The insurance companies here have tendered their policy limits, and that's essentially what's going to be recoverable if you're pursuing the association. Beyond that, you're essentially suing yourselves because the association is going to pay any judgment. They would have to reassess the owners. So I don't think that's the smart move here. What you really want to do is try and pursue what they call a derivative action on behalf of the condominium against the engineers. And certainly there's going to be a responsibility likely for the neighboring property owner. They offered a $400,000 settlement as a result of their construction activities, which their reports caused the building to shake. So certainly I think the best paths to recovery here are going to be against the engineer, the neighboring property owner. That assumes that causation can be proved there, because we still don't know exactly what happened.
Okay, really fascinating legal analysis you're providing us with. Kevin Hirzel joining us on the program. Thank you very much. We appreciate it.
Thank you.